Good morning, everyone. It's the 12th of December, 2022 at 9 o'clock in the morning. It's a Monday, and it's the very first day in this year with snowfall in Vienna, which is a little bit of a chaos that is coming with it. It's great that you are with us, however, and it's great that all our panelists are here today. I may introduce today to you in the first Eva Koreniak-Lalovic and Katerina Polikonopoulos, both working at the Department of Innovation and Digitalization in Law. They are the two who are mainly engaged in the project we will be talking about. And then in particular, Dr. Judith Herrnfeld, who is our first guest here to be interviewed today. Dr. Herrnfeld works for the Ministry of Justice. She has been a counselor at the Ministry of Justice since 2012. And she has been working in particular on negotiations and implementations of mutual recognition instruments in criminal matters. And this is one of the key topics we will be talking about. But she's also working on legal acts of agencies. So if you ever heard of Eurojust, that is within her field of competence, in particular by drafting statements for Austria in proceedings in front of the Court of Justice of the European Union. Before that, she worked within the Public Prosecution Service Vienna as a public prosecutor on general matters, but also there on MLAs. If you should not know yet what that is, you will certainly learn this here, and on extradition cases and white-collar crime. And before that, she received training as a judge at variant and different Austrian courts as a judge and a prosecutor. Her education is a Viennese one. I'm very proud to say that she is an alumna of the Law School of the University of Vienna, where she received her diploma and also her PhD. And she is one of the experts in the domain we will be talking about. Let me just introduce very briefly to you before asking the first question, the project. So this is TREIO. This is the project you might have a look into. This is the website if you want to have a little bit more of information about the project. It's about training in EIOs, and we will therefore clarify what EIOs are and who should receive here training and for what purpose. So my first question, therefore, to Dr. Herrnfeld is easy. It's whether you could briefly explain what the European Investigation Order is and in how far this regime has changed in the last years.
Yes, thank you very much for inviting me. I'm also very proud and grateful that I can attend this session and talk to you. An EIO, a European Investigation Order, is an instrument for cross-border cooperation between judicial authorities from different EU member states. More specifically, it is an instrument for the collection of evidence and an instrument in the area of so-called mutual recognition. And mutual recognition means that in principle, judicial authorities from one member state issue an EIO, and judicial authorities from another member state should in general enforce this measure. The reasons to deny enforcement are limited, and according to the jurisprudence of the Court of Justice should also be interpreted narrowly, so to enhance cross-border cooperation. And before the EIO was applicable, cross-border cooperation was based on mutual legal assistance. And in my view, there are the following differences between this older MLA regime on the one hand and the new regime of the EIO. That is, firstly, that the directive on the EIO aimed at unifying the different legal regimes that we had under the MLA, because there we had several different legal bases, for example, Council of Europe Conventions on mutual legal assistance, or the 2000 EU MLA Convention, or the framework decision on freezing orders. So the EIO mainly aimed at creating some kind of one-stop shop legal basis for cross-border cooperation. And secondly, the EIO also limits the necessity for double criminality. Of course, it's not totally excluded to refuse an EIO on the basis of double criminality, but there are some limits to it. So for me, these are the main two differences between the old MLA and the new EIO directive.
Thank you, Dr. Herrnfeld, from my side as well for joining us. I'll ask you the next question, which is, do the old MLA procedures, are they still available to member states, or is the EIO now the compulsory and only way to exchange evidence internationally?
Well, within the EU, the EIO mainly replaces the old MLA regime, but we have some geographical differences because Denmark and Ireland have a special status. As you know, Denmark did not ratify the Lisbon Treaty, so is therefore generally excluded from applying the EIO directive, and Ireland has the possibility to opt into instruments of mutual recognition, but has not declared such an opt-in. So for both those states, it is not applicable, the EIO directive, but otherwise for all the other EU member states, it is applicable. However, from the substantial area of application, there are also some exceptions to the application of the European investigation order, but these are quite logical, I would say. So, for example, it doesn't apply to joint investigation teams because the gathering of evidence within a JIT follows very specific rules. And secondly, for example, there is this service of documents where one member state just wants to deliver an order to a person living in another member state. And of course, this is not for evidence collection, so it's quite logical that the EIO does not apply to those mutual legal assistance requests.
And going back a little bit to the purposes that you mentioned for the issuing of this EIO regime, you mentioned that unifying the different systems was the main purpose, and then, of course, also limiting the necessity for double criminality. Was the pervasiveness of e-evidence also a motivating factor for the EIO system, or is this something that was more a motivation for EDES?
That's a little bit of a tricky question. I would say neither, because the EIO clearly also applies to the gathering of electronic evidence, and the EEDES system aims at digitalization of cross-border cooperation so that the transmissions between the issuing and the executing member state are done electronically. But with the gathering of electronic evidence, it's a little bit tricky when it comes to retrieving the data. So, for example, with regard to telecom service providers, it is rather easy. If, for example, an Austrian prosecution service wants to gather data from Deutsche Telekom, it is clear that the Austrian prosecution service would have to issue an EIO and transmit it and send it to German authorities, and the German authorities would then retrieve the data from Deutsche Telekom. However, we have other service providers that offer the services in the EU, but they do not have a seat or a subsidy in the EU, so it is not possible to address those service providers with orders. And this is where the problems with the gathering of electronic evidence starts.
Thank you also for joining us from my side, Dr. Herrnfeld. And since you already mentioned the national authorities, Austrian prosecution authorities, and so on, we understand that you were at the Ministry of Justice when the EIO and EES systems were being discussed and implemented. So my question would be, how were these changes or the new requirements perceived? Did the ministry agree to these new changes? Yeah, so how was this background, if you may give us some background? Yeah.
Thank you very much. Yes, indeed. I mean, when the draft for the directive on the EIO, it was not a commission proposal, but it was a member states initiative. And Austria was one of the co-sponsors of this member state initiative for the directive. And I think this shows the great interest also of the Austrian ministry to support the changes. And the same goes for the EES system. I mean, my colleagues that work on digitalizing the justice system for Austria, they are very ambitious, so they were also very interested in joining this initiative on EES. And after all, for the time being, it is a voluntary project, so member states are not obliged to take part in this project of this EES and the electronic transmission of European investigation orders and evidence gathered back again to the issuing authority. But we've been there from the very start. So we've always been interested in digitalizing not only our national system, but also the cross-border communication with other EU member states.
Very good to hear that.
So perhaps we went a little bit too quickly into the EES topic because I think some of our listeners may not actually know what the EES platform is. Dr. Herrnfeld, would you please explain a little bit about that? It's pretty straightforward, but
Yes, thank you very much. I will try, although I'm not a technician. I mean, in the civil area, we have already various projects where cross-border transmission is digitalized. And there is a platform that is called the eCodex platform or system that works as a basis. And the EES system is now specifically designed to digitalize the cross-border cooperation in criminal matters. And well, let me just think whether I get the abbreviation together in what it means. I think it's the electronic evidence digital exchange system. Yeah, so I think that's it. So we had to design a reference implementation at union level where we digitalize the EIO form and put it together in a digital version, and to create what to click and where you would have to insert text and so on and so forth, but also think of all the possible communications that come after that, and to foresee all kinds of use cases, what issuing and executing authority might communicate with each other and so on and so forth. So this was mainly the work that we did with the EES system. I hope that answers the question a little bit better. But I think my colleagues from the technical department will be able to share far better and more extensive information on that.
Thank you. No, I was actually just looking for something along the lines of it's the electronic platform for exchanging EIO requests. So that's very detailed. Thank you. And I'd like to get into the mechanics a little bit of an EIO request for our listeners who maybe are not prosecutors or judges. So my first question is, how do you identify, because multiple parties could receive an EIO request, right? How does one identify the specific authority to which an EIO should be addressed?
Yes, thank you. So in that regard, the EJN Atlas is rather helpful. The EJN is the European Judicial Network. There is one for civil matters and also one for criminal matters. And this atlas that I refer to is available on the EJN homepage, and there it's really a very easy thing to find it. You just have to click through all the steps in this atlas. First, you have to type in the country and then the measure that you want to enforce in that country, and step by step you will retrieve the data of the authority that should be competent in the partner member state, so to say. And if you're not able to find the executing authority on the EJN Atlas, you can also get in contact with your EJN member, because it's a network and it contains of contact points in all the member states. So if a prosecutor is lost, he can also write an email or phone his or her national member of the EJN and try to work things out with him or her. And if everything goes wrong, there is still also Eurojust, as was mentioned initially already. So I think with that, you should be perfectly fit to find the authority.
So as a practical matter then, who sends the EIO? Is it the judges or the prosecutor's office? And who receives and executes it? I know these are pretty basic questions, but...
No. You're absolutely right to ask those questions. I mean, it from country to country, it will depend on the implementation of the EIO directive. In Austria, our investigation is prosecution-driven investigation. So in Austria, it would be the prosecution service that would issue an EIO. In other states, it might be different. For example, in Belgium, we still have an investigative judge, so it will be most likely it will be the investigating judge issuing the EIO. I mean, coming back to Austria, in case the prosecution's service filed an indictment, then it would be, of course, for the court to issue an EIO, because the court is in charge of the proceeding after the indictment. And when it comes to the recognition and enforcement of incoming EIOs, so if Austria receives an EIO from another member state, it is mainly the prosecution service. There are some exceptions, but they're so they don't have any practical relevance, in fact, where the court would be competent. So it's mainly the prosecution service that would be competent. And I would like to add one specificity of Austrian law, because particularly when Austria is issuing an EIO, because in the field of the European arrest warrant, we had issues regarding prosecution services that are subject to directions from an executive authority, namely the ministry. I mean, it's not that sensitive for the EIO, but still, even though in Austria the prosecution service is competent to issue an EIO, it is necessary for the prosecution service to base the EIO on the necessary national orders. And if for a certain investigation measure a court authorization is necessary, then the prosecution service is obliged to seek court authorization before issuing the EIO. So in any case, for any measure that is very intrusive, you would have a court authorization for the measure, even though only the prosecution service would issue the EIO in the end.
Okay, so I understand that you do not actually need court authorization for all EIOs. Where's the line drawn? When is it that that the prosecution needs to consult with the court?
I mean, for the EIO and for issuing the EIO, you would never need, or the prosecution service would never need a court authorization. But we implemented the directive in a way that before a prosecution service can issue an EIO, it has to make sure that the necessary orders at national level are adopted. And if for a certain measure there is a court authorization, then or if if in accordance with the criminal procedure code for a certain measure a court authorization has to be sought, then this has to be done before you issue an EIO. And this is particularly the case for house searches, for
phone tapping?
Wiretapping, of course, and also collection of traffic data, location data, also telecommunication traffic data and location data. And there are some few other measures like any, audio or video surveillance of a person would need to be authorized by a court.
And does it matter if the data has already been collected, or if the order is a request for data to be collected?
Exactly, the latter. So if you if the EIO aims at retrieving data that has been already collected by the executing authority in, for example, their investigations, then this would not apply.
And you mentioned earlier that there are certain bases on which an executing authority can refuse to honor an EIO. Do you know off the top of your head what those bases are? A few of them, perhaps?
Yeah, I mean, the directive has to be implemented. So the implementation of those grounds for refusal, as we call them, they might vary from member state to member state. I mean, you cannot go beyond what you have in the EIO directive, but these are the minimum standards. So you can say that, or you can choose not to implement all of the grounds for refusal. However, the Austrian legislature decided to stick more or less very close to the directive and implement all the grounds for refusal, basically. I mean, that was, I think, generally. So, I mean, among others, or let's say, I think in practice, double criminality plays a very important role when it comes to grounds for refusal. And otherwise, I would also say what I would call double legality of a measure also plays a very important role. So that means, or what I would understand, or what double legality of a measure means, is that if in a certain, if under the same circumstances, the requested measure is not available in the executing member state, because, I don't know, the measure is limited to a certain category of offenses, then the executing member state can refuse to execute the EIO. And I think those two, double criminality and the so-called double legality of a measure, these are the main grounds for refusal that are applied in practice.
Okay. And is there any category of evidence that is excluded in the EIO or in the EIO regime?
Yes, you could say so. I mean, for example, the most important and prominent exception, of course, would be material that is subject to the lawyer-client privilege. But in general, you could say that all material that fall under a privilege under the law of the executing member state cannot be retrieved. And the same also applies to classified material due to state security reasons and so on. And so that would be excluded. I mean, there are grounds for refusal, but in fact, they are excluded.
But generally, as long as it's admissible in court, then it's subject to an EIO.
Yes, of course. I mean, it is always possible to issue an EIO, but on the executing side, the executing authority might refuse to enforce the EIO and to give the data, the evidence, to the issuing authority due to those grounds for refusal.
And maybe one more question from my side. So you already mentioned that there are like differences between national legal systems. And I'm not sure, maybe if I understand correctly, maybe you can clarify. So, or you can confirm that. So can an EIO be issued for a crime that is not recognized in the country of the executing authority, but it is a crime in the requesting country, or can the country or can the executing authority refuse to issue then EIO?
Yeah, I mean, you touch upon this problem of double criminality, where I already mentioned that the EIO limits to a certain extent the grounds for refusal on double criminality. I mean, the issuing authority can, of course, always issue a European investigation. But what I tell my colleagues in practice all the time is that they should be aware that there are those grounds for refusals, and double criminality is one of the most commonly used grounds for refusals, I would say. So there are two exceptions to double criminality. And the first exception is that for certain measures, it cannot be applied. And those measures can be found in Article 10, Para 2 of the directive. And among several other examples, double criminality, for example, cannot be invoked in case an authority requests the hearing of a witness, expert, accused person, and so on and so forth. And it can also not be invoked in case the identification of persons holding a subscription of a specific phone number or IP address is requested. And there are some other exceptions from double criminality if you look at Article 10, Para 2. And there is another exception in the directive, and these are for offenses that are listed in Annex D of the directive. Those are several categories of offenses. One of them, for example, being cybercrime or fraud or murder and so on and so forth. And there is another requirement because the offense must be punishable in the issuing state by a custodial sentence or detention order for a maximum period of at least 3 years. So if you have those two requirements, first of all, category, the offense is one of the offenses listed in Annex T, and you have the punishment requirement, then you can be rather sure that the executing authority cannot invoke double criminality. So these are the exceptions, and for everything else, you have to be prepared as an issuing authority that the executing authority might refuse the EIO on the basis of double criminality. I hope that answers the question.
Yeah, no, definitely. Thank you for that. And since we are already talking about the differences between countries, also respect for fundamental human rights differs between countries and European countries. So do you think, or do you perceive this kind of liberal sharing of information under EIOs risky, given this variability?
Yeah, that's a good question, and I think also a rather sensitive question. I mean, in respect of risks of sharing data and fundamental rights, I think we should always bear in mind that the collection of evidence might also be for the benefit of the accused person. It could also be that it's exculpatory evidence that will reveal that the accused is innocent, right? But I mean, if you take a closer look at the jurisprudence of the Court of Justice of the EU, you can definitely say that all instruments of mutual recognition rely on mutual trust. That means trust that all legal systems of the EU member states are in the position to conduct criminal proceedings in line with the requirements of fundamental rights and freedoms. And you can also see from the questions that courts of the member states refer to the Court of Justice of the EU for preliminary rulings and the judgments that the court delivers, that the sensitivity for the matters of fundamental rights is definitely rising. Yeah, so I mean, as I said, for collection of evidence, it's rather complicated because, of course, despite those various legal systems that we have in the EU, impunity should be avoided, of course, and we should also see that the overall situation is that within the EU we have a very high level of protection of human rights. So yeah, it's a little bit sensitive, the question, but yeah, I hope I touched upon some issues that answers the question.
That makes a lot of sense that MLA procedures in general are based on mutual trust. From a just practical matter, do you think that the e-codex system is likely to make perhaps an incongruency between countries more stark? Is it going to make it easier to issue EIOs that perhaps where perhaps in one country there is this tension between respect for fundamental rights between the issuing and the executing authority?
I would say that this digital platform increases, in fact, the respect for fundamental rights because it provides secure channels of communication and that addresses, of course, data protection issues. And the matter, for example, of proportionality of an EIO is, I mean, for me there is no connection because it's only this EES system is only a mean of transportation of an EIO, so it has nothing to do with the requirements that you have to meet to issue an EIO. These are separate questions for me.
Okay, that makes sense. And you mentioned the proportionality test that needs to be conducted before evidence is exchanged. Is this to be performed using the standards of the issuing authorities' laws, or is it the receiving authorities' laws?
I mean, in first place, it is, of course, a task of the issuing authority to assess the proportionality and the possibilities and powers of the executing authority to challenge, so to say. These findings are rather limited, I would say. But they're only limited and not totally done away with. So also the executing authority has a role to play in assessing the proportionality of a measure when it comes to the enforcement. And you can see that in two ways. First of all, there is the possibility to revert to a different measure. Article 10 of the directive on the EIO allows that, particularly where this other measure would achieve the same result by less intrusive means. And I would also say that the ground for refusal on what I mentioned in respect of the double legality is also something where proportionality of the measure plays a certain role.
Thank you so much for this overview. I really, really appreciated this because it was masterful in giving a detailed perspective on where the issues are and also where the options are. I just have one very fundamental question to add, if I may, which is, does time and time pressure play any role here? Because when it comes to digital data, we know that they might have the tendency to disappear. So is there a different procedure when the access to the evidence is urgent and there's a high risk that something might be destroyed without imminent action? Does time play a role here?
Yes, indeed, absolutely. So there are special deadlines that have to be met, and they're really very short for the executing authority because when this provisional measures, as the EIO refers to them, are sought, then the executing authority should decide within 24 hours what to do to recognize the EIO or not to recognize the EIO. So it's really a very urgent procedure then.
Yeah. Okay. Thank you so much for this, Dr. Herrnfeld. I very much appreciate this. Thank you very much, Eva. Thank you very much, Katharina. If the topic is of importance to you, stay with us. There will be a series of 4 episodes like this one here. And I do hope that we get an overview about what's happening here in Europe on this. If you want to do some research by reading, again, this is the website of the project we are talking about. Thank you so much to all of you. Have a wonderful day and a wonderful week, and enjoy the winter if you can. All the best. Bye-bye.
Thank you.
All the best to your project.
Thank you very much.